Good evening, everyone. This is our last session of company law. We're going to cover the concept of winding up in this session. And without any delay, let's proceed with the session. Yes. So first of all, we have to understand what exactly is winding up. So see, winding up of a company, it's a process. See, it is saying it's a process. Now, this in itself, let us understand this word, that why do we call it as a process? When there is a company, for certain reason, if any of the members who have the rights to actually put a request to wind up a company, then what is there are two concepts. There are two concepts. One is winding up, and second is dissolution. Dissolution of a company. So there are two processes, winding up and dissolution of a company. When we talk about winding up, it means that a process where a party, where a company, members of the company. Now, who all members of the company? There could be shareholders, there could be the directors, there could be key managerial, KMP, key manager personnels, and these creditors. So what they do, they put a particular petition in front of before the NCLT, which is National Commission for Hello. Yeah. So what they do, they actually put forward this particular petition before the NCLT, and this particular petition, if it is after the petition has been filed, the court will look after all the facts on which the members are asking for the winding up of the company. On which the members are asking for the winding up company. If found suitable, the court will appoint an official liquidator. Now, this official liquidator is responsible for all the official liquidator is responsible for actually administering the company's assets. In terms of all the assets and liabilities will be assessed by the liquidator, and all the debts, if there are debts, they will be taken care by the liquidator. And if at all, after all the liabilities which have been taken care, now the one thing will be left will be surplus. If in case any surplus is left, then the surplus will be distributed. Surplus will be distributed among the members of the companies according to their shares they hold in the company. Okay, so that is how it is a process. Now, winding up of a company does not mean that the name of the company will be not visible in front of in the register of register of the company. You won't. It doesn't matter. It won't lead to this particular thing where you won't see the name mentioning of the name of the particular company in the registers, right? It is not the case. The company, if the company, let's say XYZ, if this company has been winding up procedure has been done, yet the name will still be shown in the ROC. Okay, so now the name will still be shown, but now the second step will be the dissolution. The dissolution is always done by the court. That this is the process which is only done by the court, and this dissolution process then will make the company existence, just to remove the mere existence of the company. So at this stage, the company still exists, means winding up stage, the company still exists. When we talk about the second stage, that is the dissolution of the company's existence is removed by the court. So winding up, it's the process to which dissolution is, and dissolution is the conclusion. Okay, so let us understand winding up is a process in which a company is dissolved by clearing all the debts or liabilities, dissolution of its assets is collected, and other important items are returned to the creditors. And if any contributors are made by the members, they're also returned. Any contribution that is made by the members, and any important item that belongs to the creditor, it is all returned to them back. Therefore, winding up, we can say it's a process. Always it's a process of putting an end. It's a process to which we reach to the dissolution of a company, which is a final process, which is like when the existence of a company is put to an end. The winding up is mere a process of putting the company to the end. If the company has any surplus left, then it is also distributed to the amongst the members according to the rights they have in the company in terms of now. This is also called as liquidation. Winding up, आप इसको liquidation से भी समझ सकते हैं. It is also called as liquidation. So winding up means winding up under the act or liquidation under insolvency and bankruptcy code. जो winding up का जो process आपका है, ये तो आपका NCLT देख लेता है. ओके, बट जब हम बात करते हैं लिक्विडेशन डिसोल्यूशन का, तो डिसोल्यूशन का प्रोसेस होता है हमारा इंसॉल्वेंसी एंड बैंक्रप्सी कोड के थ्रू, which is this. The winding up means winding up the act or liquidation under the as applicable. Okay, so if we see again that what is winding up, so winding up, we understand that it is a process. It is a process. Then number 2 to mention, process of what? By which process by which the life of the company is put to an end. Yes, it is put to an end, right? But finally, it's not ended. It's the process by which the life is put to an end. Okay, because finally it will be not in the existence through the process of dissolution only. Now the process, its property, whatever property belongs to the company is administered. It will be administered well by the liquidator. For what process? For the benefit of the members. Benefit of the members. Or creators who have created the company, right? Now there a person will be, the property is administered. Who will be administering these property for the benefit of the members? An administrator of a liquidator. A liquidator does that, right? And who is appointed by the court? When this liquidator is appointed, when the application or petition is filed in NCLT for this purpose, then. Okay. The next is the liquidator. This particular liquidator will take control of the company. The liquidator will take control of the company, and what he will do, he will collect the assets. He will collect the assets. Liquidator will collect assets. After collecting the assets, he will pay the debts of the company. And after paying the debts, whatever surplus is left of the assets, which is called surplus, that will be distributed. That will be distributed amongst the member according to the rights in their company. So this is the entire process of this winding up. Basic process. Okay. So now if we see that the next we have to understand what is the difference between winding up. I'm talking about this particular topic, which is winding up and dissolution. And what is the difference between these two? The term winding up and dissolution differ in many ways. The whole story of achieving a legal finish to the existence of an organization is particularly in two phases. First is winding up, and the second process is dissolution. So it's a process to which we reach to the dissolution of a company. Now, like I told you, when it is this is the first step, and this is the final step. So winding up is the first stage in the process where the assets are realized, liabilities are paid off, and the surplus remaining is distributed among the members. Whereas if you talk about the dissolution process, it's a final stage. It's a final stage whereby the existence of the company is withdrawn from the law. Now you won't find the name of the particular company in the register of the registrar. The liquidator appointed by the company or court carries out the winding. Either the court appoints the liquidator or the or the company only appoints its own liquidator, and then the particular liquidator will wind up the take care of the winding, or we take care of the winding process. But the order of dissolution, see, liquidator appointed by the court or winding up process, but the order of the dissolution is passed by the court only. Winding up in all cases, because why only court? Because court may also reject uh, for the dissolution of the company, because maybe it puts a bigger harm. It puts a bigger harm on the country or on the people or public in general. So in that case also, the winding up in all cases does not finish in dissolution. जरूरी नहीं है कि सारा winding up process आपका dissolution process तक reach करे. तो winding up process में company is solvent company, मतलब the company has still the asset, still has the capacity to pay off its debt, right? So maybe the company still rejuvenate, right, after paying up all the liabilities. So even after paying all the creditors, there may be case, there may in any case be a surplus. The surplus may acquire, the company may acquire benefits of profit during the कोर्स ऑफ वाइंडिंग अप. सो जो सरप्लस बचता है तो कंपनी उससे वापस से रिवाइव रिजुबिनेट कर लेती है, and there may be a scheme of compromise with the credit, and at last the company can go back to the shareholder and old management of the company. And a dissolution is an act of putting an end to the life of company. Lawfully आप उसको end में end करते हो dissolution में. Okay, this is a difference. And the next is dissolution of an organization. When we talk about dissolution of an organization, we talk about it's two ways. Number one is first in which the organization is moved to another organization. एक organization जब दूसरे ही organization में move करी होती है recreate करने के लिए, उसको combine करने के लिए, जिसमें से merger मैंने आपको बताया था. In such a case, the exchange of organization will be broken down by request of tribunal without it being twisted up. And the second situation, dissolution क्या होगा? The organization will go through a wrapping of measures where the resources of the organization will be acknowledged and they will continue utilizing it to pay its liabilities. And when the obligations have been settled, the leftover sum, जो हमारा surplus होता है, that will be circulated amongst the partner, and the tribunal will pass the request for the disintegration of the organization and strike its name off the registrar of the register of the company. So that is going to be the process. So before I proceed further, I would like to quickly give you the meaning, the modes of winding up. The modes of winding up of a company. So what are the modes of winding up of a company? If that's the question. And basically there are two modes. Number one is compulsory winding up. And the other one is voluntarily. Compulsory and voluntary winding up. So when we talk about the compulsory winding up, so this one is basically under the Companies Act 2013. When we talk about the compulsory, and it means compulsory means by the court. Now voluntary is either by the members or by the creditors, either. And when we talk about the compulsory, it is done by the court. Okay, so this is by the Companies Act 2013, and this is by the IBC 2016, Insolvency Bankruptcy Code 2016. This one is that. Okay, so this is how they both are different from each other. Okay, so if we talk about the compulsory winding up, it's called compulsory because it is done. The first thing you have to understand is why compulsory, because it's done by the order of tribunal. यहाँ पे tribunal कौन सी है? NCLT. So it is done, the compulsory compulsory winding up is done by the order of the tribunal. तो ट्राइब्यूनल, अब ये जो ऑर्डर ट्राइब्यूनल बनाएगी, ये दो तरीके से ऑर्डर बना सकती है, या तो वो सू मोटो बना सकती है, सू मोटो मतलब ऑन इट्स ओन मोशन, on its own motion. Okay, so this could be on its own motion, and the another one is, this is the one process, and the other processes which, like when the court finds out that the particular company should be wind up, and the another one will be when the application has been received by the company. Application received by company. Modes, or any specified, any person who is specified. The question is who all are these specified person. Now these are like, if you will specify where under section 272 of Companies Act 2013 अगर आप देखेंगे तो उसमें clearly mentioned है. So few of them are like company itself, right? The creditors of the company, then the registrar of the company, or any contributory, or shareholders also. So any of them can actually raise this question of winding up the company. Another thing that you have to understand is, another thing which we have to understand is grounds. It's grounds. So what are the grounds for the compulsory winding up? So number one grounds, if you understand that it is by the special resolution passed. It is by the special resolution by members. So what matlab, in a special resolution, first of all, number one, the special resolution process, that the winding up can be done by passing a special resolution, should have a mentioning where? Should have a mentioning in the MOA. In MOA आपका इनमें mentioning होनी चाहिए, that this could be one of the way to actually put the company to end. And what is special resolution? Now these resolution means where the voting, you are getting around, say at least 75% of the voting you are getting on a particular resolution that you need to pass. So 75% of the people must be supporting a particular resolution. So minimum. And sometimes it goes to even 95% of the voting. So that means 75% of people should be supporting that particular resolution. And thereafter only it is called special resolution. Okay. So this, and another one we have to talk about is just and equitable. Just and equitable. So what is just and equitable? So it could be anything which the members of the companies or key managerial personnel of the companies find really important, moral to do for the benefit of all, right? The just and equal, it is the members of the companies find it quite just, quite equitable to do that particular act of winding up the company. For example, now there are so many debtors who should be paid. There are so many debenture holders whom the amount should be paid, and now it's a time. Now's the time that you should be actually paying them back. And now that process is obviously through the winding up, where the liquidator actually release all the assets and pay off the liabilities, and whatever the surplus is left, then that surplus is properly distributed amongst the members of the companies, and according to the shares they hold, the right they hold in a company. And in case any compromise is done between the shareholders, then the company can also revive, or company can also be rejuvenated, and which means that from winding up, the company will not go to the process of dissolution. Okay. So just and equitable is to basically remove the complete deadlock, right? For example, now it is not possible that the company's members can never meet, right? It's impossible that they can ever meet. So just to uh, get rid of that deadlock, right? Unable to meet, maybe one of the member died, right? Something. Now the fraudulent purpose. Now it has become a fraudulent purpose. Matlab, now the company has ventured into something, some new area, and that particular new area is fraudulent. The purpose, the object of that new area is fraudulent in nature. Let's say they are actually dealing in opium. They're actually dealing in opium, and it's obviously barred by the NDPS Act, right? So you cannot do that here. So that this is the point now, the fraudulent purpose. Now the company is making most of its revenue, and it's also going in loss because of the new business that they operations that they are into. So for that purpose also, it's fine if the company should take a call and find it just and equitable to actually wind up the company, and anybody who has actually suffered monetarily from the company's act and operations should be paid off. So that is one. And the other is that there are certain losses. So much of losses are suffered to the by the shareholders, by the debenture holders, by the creditors, any contributors per se. So they all have facing loss. So much of loss they are facing, and now it is highly required that these people should be paid their money back. Now it's important the money should be paid them back, and now the process of winding up will should come in between, right? The petition will be filed by before the NCLT, and NCLT, and the company will NCLT, after finding it appropriate, will actually appoint a liquidator. Either the company, either the court will appoint a liquidator, or the company can also appoint its own liquidator who will take care of the assets and will obviously pay off the liabilities, and the surplus remaining will be very well distributed amongst the members of the company according to their rights or according to their voting share they actually own in the particular company. So this is one thing where it is mentioning that complete deadlock, fraudulent purpose, losses, etc. So if there's any loss which has been suffered by any creditor, any contributor, any shareholder, or any debenture holder, any loss that they are facing due to the operations of the company, they should be paid back. It should be fined. It should be a particular just and equitable process wherein they should be actually taken care of. So this is one of the things. And the other ground for compulsory winding up will be failure to file financial statement, or you can say annual return with the registrar. So that is also one of the very important process that a particular company should adhere by, right? The failure to file financial, failure to file financial statement or annual return with the registrar. So this is one thing, that failure to file financial statement or annual returns with the registrar. So that is one, again, very important thing that we are mentioning it here. So we talk about failure to file financial statement or annual returns with the registrar. This is one very important thing because see, this is one of the very important aspect, which is not aspect, but one of the very important compliance that has to be fulfilled by any company registered. And financial statement or annual returns, if unable to be filed with the registrar of the company. The court suo moto can take action. The court here, I'm talking about the tribunal, sorry. The tribunal, NCLT, will suo moto take action against the particular company and will appoint for a liquidator to wind it up, right? So this is one of the process, and the another one is when company acted against the interest of sovereignty and integrity of a country. So when now, how is that even possible? Let us understand that as well. Against the interest of sovereignty and integrity of India. So when the company acted against this interest, for example, the security of the country is at risk. Certain kind of you are doing some kind of let's say combinations or amalgamations or acquisitions. You're doing it, and which might with any foreign entity which is actually an enemy of the country, right? And you're actually making a certain collaborations in terms of acquisitions, in terms of amalgamation, in terms of mergers. You are doing it with particular company, with the country company which is existing in another country, which is an enemy nation. So this way, it actually hampers with the interest of sovereignty of a country, right? Another one is the integrity of India also. Sometimes you're, for example, you are working in the supply of supplying all the things like weapons, armories, right? So armors and weapons, all these things you are fighting with, your actually operations involves this, where you manufacture a variety of high scale weapons, right? And those weapons are um, you actually circulate, you actually sell it across the world, and this actually leaves a bad impact on the country's image, right? So this is also one of the things that when company acted against the interest of sovereignty and integrity of India. So that is also, so if these things are found by the company, sorry, by the court, then court will issue certain um, action, appointment of a liquidator. Court will take care of that. There are more grounds to it as well. The next round is fraudulent affairs, right? Fraudulent conduct. Yeah, fraudulent conduct of affairs. So company has is now venturing in certain way, or company is handling its operations in certain way that the it's in a way that it involves fraudulent activities. So this thing, obviously we have to understand that the fraudulent conduct affair is very, very important here. So if on the NCLT will find that any company is involved in any fraudulent activity, the affairs are fraudulently infused, then the NCLT can take suo moto actions. And the last one here will be the company is unable to pay its debt, right? So if the company is unable to pay off its debt, so it becomes the liability of the certainly it becomes um, the kind of action that should be taken care by the NCLT, and because people at large are affected by the non-payment of releasing of the debts. So court may take care of it, and court soon will appoint a liquidator, and the assets will be released, and the liabilities will be paid out of that. Out of that, and liabilities in terms of liabilities means that all the debts will be paid off. So this is one of the things. Now the next one is voluntary. So when we talk about voluntary, we talk about voluntary winding up. What does that mean? For example, if you talk about voluntary winding up, we're talking about we're talking about the winding up which is done by the members of the company, which is done by the members of the company, or like I said, or the creditors of the company, right? The court is not involved, like they request the court for winding up, right? So number one thing is it is done by the company, members of the company only, right? Members of the company. And the next one is how do they do? So obviously they do it by passing a special resolution. Special resolution they pass. Okay. And that special resolution is passed in the general meeting of the company. Okay. They pass a special resolution. Okay. So again, like I said, what is special resolution? We mean that at least 75% of the voting should be done. And in certain cases, even if this number goes to 95% of the voting in favor of the particular resolution, that is called special resolution. So you need to have that particular action passed by at least 75% of them. Means you need to get it passed through special resolution. And then this process in itself should be supported, well supported by through the MOAs that is put, that is basically submitted by the court, to the registrar of the company in the very beginning process, which is registration of the company, right, incorporation of the company. So that MOA should have this mention that in case of binding up the company, it should only be done through special resolution, right? So that should have its mentioning there. Okay. So this is one of the way where the company can be winded up. And then another thing is that on expiry of period of conduct of the business, for example, in AOA, if it is mentioned that after the company, after let's say after 10 years, the company will be wind up when the operations are absolutely over with regard to this. So after this said 10 years, once the 10 years over, the company will specifically on its own go into this process of winding up. That is another, but then again, it should go according to the AOA. AOA is your article of association. What is article of association? We have already discussed this in previous sessions, but let me just give you a small idea of it. Article of association is the kind of a charter of a company in which what is mentioned, in which it is mentioned rules and regulations of how the company's operation will be dealt with, will be taken care by, is mentioned in your article of association. And that's why I said that in article of association, if it is mentioned that after 10 years, the company, after the 10 years, the company shall be expired, right? Sorry, the company will go through the winding up process and therewith with the dissolution process. Or if in the article of association only, it is mentioned that on the occurrence of a special event, on the occurrence of the special event, right? Like on the occurrence of a special event, if that particular event means it's a basically contingency, it's based on the contingency. तो contingency means यहाँ पे आपने कोई future condition दे रखी है, if any future condition or contingency happens, then you will be taking care, then the company can be wind up. So this is also, and that if that special event happens, the company shall be dissolved. And dissolution के थ्रू, मतलब डिसोल्यूशन तक पहुंचने के लिए आपको ऑब्वियसली वाइंडिंग अप प्रोसेस के थ्रू जाना ही पड़ेगा. वाइंडिंग अप प्रोसेस ही होता है कि डिसोल्यूशन तक. वाइंडिंग अप प्रोसेस एक्चुअली टेक्स केयर ऑफ ऑल द एंटायर प्रोसेस, like I told you, paying off the debts, right? And analyzing the total amount of assets the company holds. Then out of that, you have to sell that asset, and then you have to revive the amount from the you have to pay off all the debts, all the liabilities, right? And then the fourth thing could be that the voluntary winding up, like I've also told you, that it is done in accordance to the IBC, that is Insolvency Bankruptcy Code. So it is done with the help of Insolvency and Bankruptcy Code only. And it's like I told you, if it is about the winding up, so these two acts are taken into consideration. Okay, so I have very well cleared you the grounds, the modes of winding up, which is compulsory and voluntary winding up. Then I have explained you how it is done, the grounds, then the voluntary winding up grounds. So pretty much the question will come up in terms of your exams from here only. Now the next question that in these, obviously PPT you can use it as your the same I have already explained you. So let us just go through this. It is saying that analyzing the modes. I've told you there are two modes, right? There are two modes for this. Number one is compulsory and voluntary mode. So if we talk about the company comes into existence when it is registered, incorporation it is talking about, and obtains a certificate of incorporation by the registrar of the company. And then it will come into existence even if an appointment is made in form of receiver or manager by the court or debenture holder, or the approval of the scheme of arrangement by the court. Now, the existence of a company is lost when the company completes two stages. एग्जिस्टेंस कब लॉस होता है? सबसे पहला तो वाइंडिंग का फर्स्ट स्टेज होता है, और सेकंड स्टेज आपका होता है डेजोल्यूशन का. और डेजोल्यूशन पे यहाँ पे एग्जिस्टेंस फाइनली जो हमारा होता है वो डेजोल्यूशन के स्टेज पे खत्म होता है. और ये टू टाइप्स की कंपल्सरी एंड वॉलंटरी वाइंडिंग अप है जो हमने अभी पढ़ा है. क्विकली हम इसको पीपीटी के थ्रू भी अंडरस्टैंड करते हैं. कंपल्सरी वाइंडिंग अप क्या होता है? टेक्स प्लेस व्हेन अ कंपनी बिकम्स इंसॉल्वेंट और बैंकक्रप्ट हो जाती है कंपनी. तो इंसॉल्वेंट एंड बैंकक्रप्ट मतलब कंपनी पर इतना पैसा नहीं है, ठीक है, इतना प्रॉफिट नहीं कमा पा रही, तो क्या करेंगे अब? कैसे शेयर होल्डर्स को उनका पैसा देंगे, राइट? कैसे क्रेडिटर्स को उनका पैसा देंगे? तो व्हाट दे डू इज दैट द assets of the company will be sold, and जो money उससे आएगा बेचने के बाद वो उनको liabilities को pay करा जाएगा. And then after payment, if the surplus is left, that will be obviously distributed among the member of the company. So when the company is ordered to be wound up by the court or tribunal, it is referred to as compulsory winding up of a company. So it is a compulsory wind up when it is ordered by the NCLT only, court, high court or tribunal. If the company goes into liquidation, the court law appoints a liquidator to complete the process of liquidation. And this particular process is mentioned under section 270 of the Companies Act, which is very important. So how like winding up has to be done. So number one is willful wrapping up happens without the mediation of the court or council. So this mode for the most part happens when the organization terminates its prefix length or because of the event of specific occasion whereby the organization must be disintegrated, and if the organization embraces and passes a normal goal for twisting up. If the company passes a special resolution to winding up company, like we have discussed. Voluntary winding up में भी अगर देखो तो दो तरीके के winding up होते हैं. एक तो member करते हैं और दूसरा जो creditors करते हैं. Members करते हैं उसका meaning क्या है? This type of winding up occurs when the company is solvent. जब member करे, solvent का meaning क्या है? They are still able to pay, right? They still able to pay. They still are able to pay their liabilities, right? So solvent है, अभी insolvent नहीं हुआ है. तो members जब voluntary wind up करते तो अभी भी उनको पे पढ़ने का भी उनकी हालत है. The company needs to declare solvency at the board of directors meeting में अपनी करनी पड़ेगी, and this declaration must satisfy the directors opinion that the company has no loan or debt, or it will pay the whole debt within 3 years of winding up. Winding up होने के 3 साल बाद तक अपने सारे डेट्स को पे कर देगा. तो ये सारा आपका उसमें मेंशनिंग होनी चाहिए, राइट? एंड द नेक्स्ट इज जो जनरल मीटिंग कंडक्ट करते हैं जिसमें लिक्विडेटर अपॉइंट होता है, अगर वो कंपनी अपॉइंट लिक्विडेटर है, एंड उसी मीटिंग में उस लिक्विडेटर का रेम्यूनरेशन तय करा जाएगा. एंड ऑल द पावर्स वंस द लिक्विडेटर इज अपॉइंटेड, all the powers of the board
of directors and managing director or manager, these ceases to exist. Now, until and unless a general meeting sanctioned it otherwise, that they still have their power. So the liquidator must annually call a general meeting to lay the procedure of winding up and to lay the accounting of it, stating that how, because now all the powers goes through the liquidator. Now he has a right to sell or to pay off the liabilities. It is his power now. So he has to also make a clear record of it, right? Now, the creditor's voluntary winding up is that this type of winding up occurs when there is a declaration of insolvency. You're declaring it that we are solvent by the company, which means what? That the company is insolvent. Now, hence, it empowers the creditors of the company to dominate over the members. Now, creditors dominate the members of the company so that they don't protest against them. And it requires the company to hold a meeting with the creditors and the boards and make a full statement of the company's affair and detail the list of creditors, including their estimated claims. Both creditors and members at their respective meetings appoint a liquidator. They appoint a liquidator. And if at all there is a disagreement, then the creditors will appoint the liquidator at their discretion. And the liquidator holds a meeting not only with the members but also with the creditors to lay the procedure for winding up and to lay the accounts for this. They are absolutely a liquidator is given the power to full on actually take charge of the company affairs, right? And whatever loss a company has suffered, that is also is being taken care by the liquidator only. So these were the one more thing, just creditors voluntary wound is basically also one more thing, that appointment of liquidator, how it is done. Like, see, tribunal by passing the order of winding up, it has the power to appoint an official liquidator or a liquidator from the panel that the panel what panel the company's liquid they under section 275 of the Companies Act. There is a rule that there will be a maintained list panel of the company's liquidator. So either the tribunal will choose it from the panel, or it will also can also appoint it from the official liquidator. Then terms of conditions for the appointment of the liquidator, or how much fees should be paid to, for how long that particular liquidator will be appointed, and what amount remuneration will be paid to him. It is all specified by the tribunal only. And the role on the liquidator is that the liquidator must file the declaration that now he is the liquidator of this XYZ company. So in certain prescribed form, which is again mentioned in the Companies Act 2013 only, that a prescription, a particular declaration should be made, and should be made within the period of 7 days of its appointment. And so that should be the thing. So apart from that, what are the powers and function of the liquidator? That is also we have to understand. See, the powers and function of the liquidator is given under section 290 of the Companies Act. And what all are they? See, first of all, they have the power to sell whole of the undertaking of a company as a going concern. They can, entire company they can sell, just so that the amount can be released to pay off the liabilities, right? And also to obtain any professional assistance, they can to go to at any length to actually obtain any professional assistance or appoint any professional to discharge his duties for protection of assets of the companies or to defend their rights. They can go to any extent, because those assets are only the one from which the debts will be paid off, right? So it is very important to take care that the assets are really taken care of, because that's the source of money, the source where the all the wrongful activities that has been happening will be restored, right? Then they have the power to also raise money on the securities of the asset of the company. Whatever assets the company has, they can actually raise money on that also. And they can also have the right to inspect or record or inspect any records or any returns of the company, any particular return which has been filed by the registrar of the company or any other authority. They can go with that, they can inspect that. So they also have the power to inspect right? Any record. So that is also one of the thing. The another one is that then they have the power to carry on business for the beneficial of winding up of the company. So see, one thing is the thought process behind the liquidator, as is appointed as a he's appointed by the liquidator, is not only to just release the debts liabilities. It's not only that, the premier process is also that maybe sometimes the winding up is this particular process is done, and after this process is done, the and assets are released, and the all the liabilities are paid off, and there's certain there are chances that a lot of surplus is left, and from the help of that surplus, the court can again go to the company can again revive their chances. So like I said, not every winding up process end towards the dissolution of a company. Not every. There are many companies that go through winding up process, and they pay off their liabilities, and they revive back to the company, they revive their existence. That's why I said that winding up does not mean that when the company is being wound up, then it does not mean that you will still see the name of that particular company in the office, in the register of the registrar of the company. You will see the mentioning, but when it is dissolved, which is a last process, which means that now it's just lift off from the mere existence only. So now that means that now the company is not in the existence only. This is the difference here we are talking about. Okay. So the next thing that we have to understand is that they can invite and settle claims of any creditor who has actually paid given money to the company for the running of the operation, or any employees. They also have the power to settle the claims of the employees. And next is to carry on business for the beneficial winding up of the company. So to carry a business, if beneficial winding up, if there is a purpose, the liquidator can restart another business with the help of in the name of the particular company only, and that particular business can the reason behind it, that business will help us to create a better winding up. For example, it will also, because there are no in this assets are not sufficient enough, right? So if the assets are not sufficient enough, which means the liabilities will not be paid off completely. So it is very important that the more money should come in, right? How will the more money come? So maybe if you will carry on the business again, which was obviously the business of the company, then the more money can come up, and then particular money can be dispensed off, right? Then also the liquidator has the power to do all acts in the name and behalf of the company. Whatever they want to do, they can do that, any act. So like I told you, director, board of directors, managing directors, the powers of these people are like they're taken off from them, right? And which is also given to back to given to the liquidator. So liquidator holds a lot of powers, right? And with powers, a lot of duties are also imposed on the liquidator. And so this thing, and also if liquidator, one more thing that I was thinking to just, okay, so this is what we have with this particular session. Let me just give you a quick revision on this, that winding up, what exactly it is. It's a process, it doesn't bring the company to the end, right? It's just the process where the property of the company is utilized for the benefit of the members and creditors, anybody who has actually given the money to the company for its running of the operations, just that. Then when the money and it means that with dissolution of the company is brought about, it involves that when we talk about dissolution, how different it is different that now the company is permanently shutting down the business, right? So winding of the company can take place for various reasons. For example, if the company has ceased to carry on its enterprise, right? Or there may be a deadlock in the management, like the members are not meeting, there's no board meeting, there's no filing of the annual report or financial report, so that has not been happened. So this is also very landmark case. It has like Barron versus Potter. that you can consider. Then maybe due to any breach, any compliance of any statutory provision that is also there, that could also lead to the winding up process. And then the shareholder dispute is there. Like I told you, I've discussed this particular topic of oppression and mismanagement. So that, or corporation is acting outside the scope of business means doctrine of ultra vires. I have discussed with you that some certain, the threshold is all the thresholds are drawn in the memorandum of association, which is filed during the time when the company is getting registered before the registrar of the company, right? So at that time, all the thresholds are mentioned in that MOA. Now, if the company in future surpasses that threshold, then obviously the company can be wound up. Okay. So never think that these two are the same words. Dissolution and winding up, they are two different stages, I would say. These are different stages, but the purpose is quite similar. But winding up is the first stage, and whereas dissolution is the last stage. From winding up, the company can still revive, but dissolution, once made, the company now cannot revive. So that is the difference here, right? So this is what it is for today. I think this particular concept of winding up of the company, which is our last session, is clear to you all. And I would again state that if you have any doubt, then you can obviously contact on this number, and you can obviously mail us here. And the notes will be uploaded on this website. You have your account here, the notes and the recorded sessions. We have 7 sessions on company law with respect to the CLAT preparation, CLAT PG, right? So you can access these recordings anytime. And if any doubt arises, do contact us on this number or this mail ID. So that's it for today. And thank you so much.